Welcome and thank you for being with us here today. My name is Dan LeBrier and I'm the Deputy Commissioner of Compliance and Investigations. We're basically the people that are tasked with both the investigation and the prosecution of various violations and offenses that occur in the workers' compensation system. Over the past about 12 months or so, I've been trying to shed some light on compliance and investigations because I understand that there's a lot of interest that gets generated in this area, and for a couple of reasons, I think. One is just the general subject matter. We do a lot of investigations and litigation. On the other hand, I think there's been a lot of mystery surrounding the process, and it's been a goal of mine over the last 12 months to kind of remove that veil of mystery and illuminate what we do. I understand that most of you are probably doing everything right 99 out of 100 times. But there's that one opportunity, that one instance in which you get a complaint, or there's that one instance in which you get audited. And I want to make navigating our system over here less stressful for you so you can kind of understand the process, know what to expect, know why we do things, and know how we do things. Compliance and investigations is split up into two groups, two focus areas. There is administrative and criminal. I want to spend some time first talking about audits and investigations and enforcement, sort of the administrative side of things, and then we'll move on to the criminal side and talk about our fraud investigation unit as well as our fraud prosecution team. These administrative cases usually start with a complaint, and complaints come in from a number of different sources, both internal and external. Texas Labor Code section 402.023 is a statutory mandate for us to develop a complaint filing process. However, the Labor Code doesn't really define what a complaint is. The actual definition of a complaint can be found at Texas Administrative Code section 180.16. Essentially, it's going to be an administrative violation. It's an allegation that somebody has violated either the Labor Code or one of the rules that we've adopted. Rule 180.2 states that any person can submit a complaint. So understand that you don't have to be the injured party in order to file a complaint. You just have to have some sort of knowledge of the complaint. A complaint in our system has a very discrete legal definition. It's a written submission alleging a violation of the Workers' Compensation Act or the rules adopted by DWC. There can also be an instance in which somebody is alleging a violation of a commissioner's rule or a commissioner's order or decision. But for the most part, it's violations of the Labor Code, violations of the Texas Administrative Code. A complaint is not an avenue for addressing or resolving personal grievances. A quick note on Rule 180.2. Rule 180.2 has been amended to basically include, in limited circumstances, a statute of limitations for certain types of complaints. The gist of Rule 180.2 and its amendment is this: if you have a complaint, if it relates to a medical fee dispute, you have to bring that complaint within 12 months of the date of service giving rise to the medical fee dispute. In the wake of this rule change, we've had a lot of questions and a lot of curiosity. People have asked us, can I still bring a complaint contemporaneous with my request for medical fee dispute resolution? And the answer is yes. You're not going to be penalized for filing a complaint alongside your request for medical fee dispute. All right, so the big picture on how complaints flow through the Division of Workers' Compensation is we receive a complaint, whether it's from an internal or external source. That complaint goes to audits and investigations where it's going to be processed and ultimately investigated. And then if it's confirmed, it'll go to the enforcement unit, which is a group of basically litigators that are tasked with litigating these issues. In the initial phase of processing a complaint in audits and investigations, we're working with a team of about 22 full-time employees. They process upwards of 2,000 complaints a year, and these are also the same people that are conducting our yearly audits. They are always busy, and in my opinion, these are the unsung heroes of compliance in the workers' compensation system. They're not the people that you see. They're not the people who stand up in court and get to show their faces and get to be the face of the division. But these people are sort of the beating heart of our regulatory efforts over here. As these complaints roll into our system, we're routing them all into the same place, and we process them in the order that they come in. If you do file a complaint, understand it takes us sometimes around 7 business days in order to get one of these things processed in the intake phase. So just be patient. We haven't forgotten about you. There's just a number of people in front of you in line. Once we get the complaint, it's going to be assigned what's called a problem report ID number, or a PRI number is what we refer to it as. That PRI number is going to live with the complaint for the duration of its existence. From time to time, we get complaints from injured employees, from lay people, from people who aren't attorneys that are practicing in the system, and they come in a little bit ambiguous or uncertain. That's okay. We've got a process for fixing that. If we get one of those complaints that's ambiguous or uncertain, what we do is we reach out to the complainant and we say, hey, we've received your complaint, but we're a little fuzzy on what it is you're alleging. And we'll ask for more information. Essentially, we're asking them to walk us through whatever fact scenario or whatever took place that they're taking issue with. As these complaints are received and looked at, the information that we get will be reviewed by the insurance specialist who's going to send confirmation of that complaint to the complainant. So what that means is you're going to get calls or emails from us stating, hey, your complaint is landed in the right spot, we've received it, and we're going to be working it up from here. Bear with us during this time frame. We try to get these resolved in 110 days or less. Just understand that we're working with a high case volume, and sometimes it's going to take us a little bit of time to ultimately resolve everything. Once we have a complaint established in our system, our program supervisor is going to assign a full-time insurance specialist to that complaint. What that means is that person is going to work the complaint from start to finish, and they're going to be with it for the lifetime of the complaint. We try to keep one set of eyes on the complaint throughout the process, just for the sake of continuity. We find that it makes for a better investigation. During this investigation, insurance specialists are going to reach out in their investigation to the complainant. They're going to also reach out to the respondent. They're trying to get all of the documents that they need in order to resolve that complaint one way or another. These can include the adjuster's notes, payment summaries, medical bills, DWC forms, first reports of injury, work status reports, MMI reports, documents establishing accrual of benefits. There are a number of documents that we're commonly seeking, and there are also documents that might be germane to an investigation that we're not normally seeking. Just understand that we're trying to back up our investigation with documentary evidence. So keep that in mind if you do receive such a request. Once all of our documents are gathered, the insurance specialist that's assigned to the complaint is going to determine if the allegation in the complaint forms the basis of an actionable case, an actionable violation. That's kind of the end run here, and there are only 2 possible outcomes. There's either confirmed or not confirmed. If it's confirmed, that's the insurance specialist saying, hey, the facts and the circumstances here and the documentary evidence that I've received, it supports the idea that there's an actionable violation of the labor code or the rules here. The other outcome potentially is that it's unconfirmed. All that means is that the facts and evidence that we have at this moment don't support the allegation. Whether a case or a complaint is unconfirmed or confirmed, you're going to see a similar process play out in either instance. If it's unconfirmed, the insurance specialist is going to send all of the evidence and the complaint to what's called a quality assurance specialist. The second part of that is we're going to close the complaint out in our system, and there's going to be a letter that is sent both to the complainant and the respondent being the person that was complained of, explaining our findings that, hey, there was this allegation, we conducted an investigation, but there wasn't enough there, essentially, and we're closing it out on our end. If, on the other hand, the complaint is confirmed, the insurance specialist is still going to send the complaint and all of the responsive evidence to a quality assurance specialist who goes through the same process. And then from there, there's going to be, again, 2 letters that get sent out, one to the complainant, one to the respondent, in which we state that, hey, we have investigated this, there is sufficient evidence here to suggest that there's a violation of the rules, and the case is being sent to enforcement. The case gets closed out in A&I, that's kind of the end of their role. And if that case gets confirmed, if that complaint gets confirmed, it gets sent over to the enforcement unit. Enforcement is a very small group of attorneys that are tasked with actually litigating these cases. There's about 7 attorneys, a couple of program specialists, a legal assistant, and a director who oversees the whole thing. They're working anywhere from like 700 to 900 cases a year. It's a very high volume practice for such a small group of attorneys. So, understand that we have very few eyes looking at these cases, and they're tasked with prosecuting all of these administrative violations. If a complaint is confirmed, it gets sent over to enforcement. During that intake process, a program specialist with the enforcement unit is going to assign that number, and the director is ultimately going to be the one that assigns that case to an enforcement attorney who's going to litigate that case up until its conclusion. There are three main ways that these enforcement cases resolve. There are letters of education, there are warning letters, and there are consent orders. There's a fourth way, and really a fifth way, but we're really going to talk about these main three because this is the bulk of our time spent in these three areas. Beginning with a letter of education, that is going to take place when an enforcement attorney reviews the allegations, reviews the evidence, and agrees that there may be a basis for believing that there was an administrative violation there in the first place, but ultimately comes to the conclusion that there is not a discrete violation of the rules or the act, and will send a letter to the respondent to that effect. Warning letters are a little bit different. Warning letters are when the attorney reviewing the case has looked at all the evidence and said, yes, I do believe that this rises to the level of an administrative violation, but it's not high on our list of complaint priorities. It's not a particularly egregious violation, and so we're going to send this letter that identifies the violation, identifies the rule or the statute that's been violated, and the facts and circumstances giving rise to that violation. And it's basically a letter that says, we've identified this. If it happens again in the future, we might take enforcement action against you. And the other side of that to keep in mind is those warning letters are ultimately things that we can consider moving forward. Have you been warned on this particular violation a number of times? If so, if you do it again, that's probably going to make your penalty more severe. So although warning letters don't come with a financial cost, there is a cost to doing business later on in the future if that violation continues. Because the whole purpose of the warning letter was to warn you against pursuing that course of conduct in the future. The third way, or the third most frequent way that these cases resolve is through what's called a consent order. Consent order is a funny name for basically a settlement agreement, and that's how I tend to think of these things. Consent order is basically an agreement between the parties in which we say, yes, this set of facts occurred, and yes, this amount will address and remedy the harm. Let's spend some more time talking about those consent orders. Let's start with the process on our end for working a consent order. We have to believe that there's sufficient evidence to move forward with a violation to begin with, and then we're going to recommend a penalty to attach to that violation. There's a lot of stuff we take into consideration. There are things that are statutorily required for us to consider what the appropriate penalty should be, but that's the job of the enforcement attorney working up the case. So basically what we'll do is we will send you a proposed consent order, and we'll continue to negotiate the case. We'll say, hey, these are the facts as we understand them, and this is the penalty that we're recommending. During this process, the parties will continue to sort of provide documentation and basically negotiate the case, because that's what we're doing at this point, is we're negotiating a case. We're not in a litigation phase yet. Discovery doesn't apply just yet. There will be some trading back and forth of documents that we think are helpful, but we're not in full-blown litigation just yet. In fact, the consent order is designed very much to avoid that process. If the parties agree, what we'll do is we're going to review that proposed consent order here internally. We want to make sure that it's correct, that it spells out the violation, and that it provides enough detail. The director is going to read and review that consent order and approve it. And then ultimately that consent order gets sent to opposing counsel for their signature and review. Once the consent order is received on our end and it's been signed by you, it's sent to the commissioner for his signature. Once the commissioner of DWC signs that consent order, it becomes a final order, and any penalty that appears inside of that consent order is going to be due within 30 days. Specifically, if it's a monetary penalty, it's going to be due in 30 days. All right, so that's kind of how the process occurs if the parties are agreeing that there's a violation and agreeing that a certain amount will remedy that violation. The process, if there's not an agreement, is going to be a little bit different. If we can't come to an agreement, the attorney over here is going to send what's called a notice of violation to the other side. And basically, it's just a document that spells out the nature of the violation itself, the facts giving rise to that violation, and how we plan to address that, specifically what monetary penalty, what sanction we're seeking. If we still can't come to an agreement, what we're going to do is we're going to file a complaint at SOA, which is the State Office of Administrative Hearings. And at SOA, that case is going to be litigated. The administrative law judge over at SOA doesn't have the final say in the case. And in fact, in workers' compensation, it's contemplated that the commissioner of DWC ultimately has the final say in these types of cases. So the ALJ, the administrative law judge over at SOA, doesn't issue a decision. What he or she issues is called a proposal for decision. And the commissioner has a few options at that point. He can adopt that proposal for decision in its entirety, or he can adopt certain findings in that proposal for decision, or he can just say, I'm not adopting this at all. 99 out of 100 times, the division is going to defer to that ALJ who's heard all of the evidence and heard the case fully litigated. But ultimately, these cases come back to the commissioner of DWC for his decision and his signature. The commissioner is going to review that proposal, like I said, and then what he's going to do is he's going to issue a final order. And a final order in this instance is similar to a final order through the consent order process. It's just final. There are provisions that would provide for judicial review if the respondent wants to take that avenue. I'm not going to get into that a lot today. That would be a lot of legal advice that I think is probably best suited for a private attorney. And if you are seeking some more information about that process, I would encourage you to seek legal counsel. So a few practice tips here in enforcement specifically. If we're requesting documents just like we do in the audits and investigation process, if we're doing that pursuant to an investigation, please comply. That is a circumstance that we consider in determining whether or not you are cooperative with the investigation. If you anticipate some sort of a delay in your records coming over to us, let us know. We're typically pretty understanding if there is some sort of good faith reason for a delay. But let us know. Don't leave us just hanging on it. The level of cooperation that we receive in these investigations is a determining factor in how we view the facts and evidence. And here's a big part. We don't punish good faith negotiations. There are a lot of cases that go just unnegotiated. And I don't know why, for whatever reason. People are just saying, yeah, we'll take the consent order, and they walk away. We are actively looking for you to provide us with a reason to lower that penalty, right? A reason to view these facts in a light that's more favorable to you or your client. We're always going to be accepting of that information, so please send it. There are too many cases that go just completely unmitigated, and essentially you're leaving money on the table for your client. So keep that in mind. And I think you'll probably have a better result ultimately. A note about our discovery orders. So it used to be you could only search our enforcement orders on our website by like the name that appeared in the title of the order. That's no longer the case. If you go to our enforcement orders page, you can now search by like keyword. I don't know what magic Google is using in order to do this, but of the more than 1,000 orders that we have posted on our website, you can search any word that appears in that document. What's really good about that is, let's say you're on the other side of a case and you're trying to get a good feel for market value of a case. Well, you can go into the search function and search for TIBs, or temporary income benefits, and you can look at the last 10, 15, or 20 violations, get a feeling for the facts that occurred in those cases and compare that to the facts of your case and kind of get a feel for what your penalty might end up being. I highly encourage everybody to go use that. Our IT department over here worked very quickly to try to get us this new tool, but it's really a tool for y'all, and it's going to serve y'all more than it is us. So I would encourage you to check it out. I think it's going to be really useful. Moving over into the criminal side of what we do, I want to talk about fraud cases. I want to talk about our fraud investigation unit, and we'll close out today in talking about the fraud prosecution unit housed over at the Travis County District Attorney's Office. To begin, we need sort of a working definition of fraud, and this isn't an all-encompassing definition, but it's going to give us a good starting point. Essentially, fraud is intentionally lying to receive workers' compensation benefits. Now, there are situations in which somebody could intentionally lie to prevent somebody from receiving the same benefits, but by and large, I think a good working definition for this point is, intentionally lying just to receive benefits. Like audits and investigations and enforcement, these fraud cases move through our fraud investigation unit and our fraud prosecution unit in a very predictable manner. Essentially, we receive an allegation of fraud. We call it a fraud referral. That goes to the DWC fraud unit, and then if it's sufficient, if we believe that there's proof beyond a reasonable doubt apparent in the case, then we're going to send it over to the fraud prosecution unit, where they have their own procedures for handling cases. If you do want to make a fraud report or fraud referral, you can find the tab on the workers' compensation site. You're going to see a link to report workers' compensation fraud, and it'll take you through the process of making that allegation, which we will receive. Like a complaint that comes in through the administrative side, anybody can make a fraud allegation. You don't have to have been aggrieved by the fraudulent activity. You just have to have some sort of first-hand knowledge or even second-hand knowledge of the fraudulent scheme at play. Typically, it's the aggrieved party, although again, we receive these types of allegations and referrals from attorneys and other system participants that kind of understand. Like their analogs over in enforcement, the fraud investigation unit is relatively small. It's a very lean group of investigators. It's about 5 full-time employees who are charged with investigating crime. We have 3 data analysts, we have 1 program specialist, and again, it's all headed up by 1 director. Our fraud cases come in through a number of different sources. More often than not, they come in through what's called a special investigation unit over at an insurance company. An SIU is basically a group of investigators that work for an insurance company full-time who are there to identify fraudulent activity inside of their claims and their cases, and they send those referrals over to us to be more fully investigated. We also get outside allegations from what we would call like tipsters, people who have knowledge of some sort of fraudulent activity. Sometimes that's a party to the fraudulent activity, oddly enough. Sometimes it's just somebody who has a close relationship with the person who's engaged in fraud. We also get law enforcement referrals. So a lot of these cases, some of these cases at the very least, will get initially investigated by a local law enforcement officer. What they do is, if they know of our existence, they will send their case over to us to be more thoroughly investigated, which is fantastic. In my experience in criminal law, most police departments outside of your really big cities are not set up to understand workers' compensation fraud. They're also not set up to investigate it. Most of these smaller departments are dealing with your run-of-the-mill everyday crime, your violent crime, your street level offenses. Those are the types of things that they're most tuned in to. Workers' compensation fraud is, again, just like workers' compensation, generally very complex, and it requires a high degree of acumen and a lot of experience to really understand and unfurl these fraudulent schemes. So we do have partners out there in the law enforcement world who will submit cases to us. We also get cases from the National Insurance Crime Bureau from time to time. The same deal there. These are investigators that have identified a fraudulent scheme or activity, and they're referring the case over to us here in Texas. So the way that we conduct investigations, we've got subpoena authority here at the division. And what that is essentially the commissioner of DWC can issue a subpoena for either a witness or material to show up on our doorstep. This subpoena authority extends not only to Texas and all throughout Texas, but it also goes into other states, which makes it very effective as an evidence gathering tool for us over here. Additionally, because we have a criminal prosecutor who is a sworn ADA under the elected district attorney here in Travis County, that prosecutor can issue a grand jury subpoena. That's going to be for the same thing. A grand jury subpoena can command a person to actually show up to a grand jury to provide testimony, or it can also be what we call a subpoena ducis tecum, which is essentially a command for somebody to produce documents in lieu of having to testify in front of the grand jury. Our final tool that we have, because this is criminal law, it's a little bit different. We can actually issue search warrants from our district attorney investigator. So that's an employee over here who is also a sworn police officer who is embedded over at the Travis County DA's office. And as a sworn peace officer, she has all of the authority that any other police or sheriff's deputy or state trooper would have. And that's ultimately to apply for a search warrant to a judge who then issues a search warrant, which allows us to gather whatever evidence that it is that we're seeking under that search warrant. So the way that it works over here is we receive a number of different fraud allegations per year. Some of them are not fleshed out at all. Some of them are just sort of bare bones allegations that fraud may have occurred. There's nothing we can really do with that type of allegation. We can't open a full-blown criminal investigation into somebody just on a bare bones allegation that fraud may have occurred. We need more than that. And if we're going to open a criminal investigation, we have to have at the very least probable cause to proceed at that point. And probable cause is going to be based on the evidence, it's going to be based on testimony, it's going to be based on facts and circumstances that are readily proven that we can ultimately go into court and show to a jury if that's the case. But what we do is we triage our cases. That process consists of a number of very experienced fraud investigators looking at the case, looking at the evidence that we have in this early preliminary phase, and deciding, hey, is this something that we can actually work up, or is this something that we're going to ultimately drill a dry well on? So for a case to make it through that process and come out on the other end and proceed throughout the DWC investigation, it's going to have more than just an allegation. It has to have some evidence that can concretely back up the allegation. Depending on the nature of the case, if it passes muster at that initial triage, if it's a very evidence-dense case, if there are a lot of documents that need to be reviewed, it will go to one of our analysts to basically pour through all of those documents, bank records, phone records, all of those, that paper documentation, to see what the fraudulent scheme is, to try to make sense of all the numbers and all the data and pick out what it is that's going to ultimately prove the case beyond a reasonable doubt. That's a very specialized process that we have over here, and again, it's something that a very seasoned, very experienced person needs to have the opportunity to do, which is why we readily accept these cases from local law enforcement. Additionally, we're going to continue to go through evidence and try to get as much that we can in the case. That could include documents. 9 times out of 10, it's probably going to include documents. Workers' compensation fraud tends to be a very document-intensive type of crime. It also means that we're going to be conducting interviews with perhaps the accused and perhaps the witnesses that may have information that's pertinent to our investigation. We might also be getting out there and conducting surveillance. There are a number of different directions that an investigation can take, and investigators, if they're good, they have a tendency to get creative and sort of think outside the box in order to get the evidence that they need to prove their case. If it's gone through that whole process, it's gone through the case triage, and we've also gotten to the point where we've gathered enough evidence that we over here feel is not only probable cause, but also proof beyond a reasonable doubt, and that's an important factor here. We're going to present that evidence to a prosecutor, whether that's our prosecutor embedded at the DA's office here or a prosecutor in a different office. We present that evidence, and the prosecutor is going to make the decision to either accept or reject that case. There's a lot of discretion on the part of the prosecutor in this phase. There's nothing that says a prosecutor has to accept a case. If they don't like it, if they don't think that it's the type of thing that a jury would bite on, if they just think that it's an incomplete investigation, they can turn it away. And that's going to be based on a number of different factors that are probably a little too in-depth for our conversation today. But ultimately, that prosecutor is going to be making a decision based on what's just and fair under the circumstances, what justice requires given the fact pattern. If the prosecutor accepts the case will then proceed to grand jury. Grand jury is less grand and less of a jury than it sounds like. And what I mean by that is it's a very, very informal process that all prosecutors have to go through if they're going to take a felony level case into court. A little bit about grand jury and the process. It's more of an investigative and deliberative body than it is a jury. It's anywhere from 9 to 12 people that meet on either a somewhat frequent basis to a very frequent basis, depending on the county, to discuss cases. And the process kind of looks like this. A prosecutor would walk into the grand jury room, introduce themselves if they're not already known by the grand jury, and 9 times out of 10, you're probably on a first name basis with that grand jury because you meet with them either every week or at least monthly. And you talk about your cases, and you talk about them very informally. This isn't a court proceeding. This is just the grand jurors and the prosecutor, and that's generally it. Sometimes there are witnesses, and there's a process for involving witnesses, but by and large, it's just the prosecutor talking to 9 or 12 people, or any number between 9 and 12. And what I mean there is, if there are only 9 people, if only 9 people show up to this particular grand jury setting, you have to get all 9 to agree that the case should proceed into court. If there are somewhere in between 9 or 12, they don't have to be unanimous. All you have to do is get 9 people to concur, essentially. So if you have fewer than 9, you can't have a grand jury session. If you have more than 9, you just have to get 9 of those people to agree. Kind of similar to the audits and investigation complaint process, with a complaint either being confirmed or unconfirmed. On the grand jury side, the grand jurors are going to make basically one of 2 findings. They're either going to true bill that case, which means that they do believe there's adequate basis for it to proceed to the court system, or they're going to no true bill that case, or what we call a no bill of that case, in which they refuse to indict the case. That's not, again, the end of the case, potentially. There's no res judicata, there's no collateral estoppel at this point. That case could be later indicted if the facts and circumstances were such that it needed to be indicted later. Suffice it to say, that's not necessarily the end of the process, but we'll proceed on the assumption that the case has been indicted and goes to court. During that process, it's going to be very reminiscent of the enforcement process. The accused defendant is either going to self-represent or they're going to have an attorney. 99 out of 100 times, if it's a felony offense, they're going to have an attorney. And then our prosecutor is going to negotiate with that attorney to try to find some sort of a reasonable outcome that both sides can live with to resolve the case. If there isn't an outcome that we can get to that everybody can live with, what we do is we set it for a trial. And the defendant can kind of choose whether they want a jury trial or a bench trial, and a bench trial is just where a judge would decide. But if they do want to waive their right to a jury, they have to do so with the consent of the state. And that's a tactical decision for the prosecutor to make. But by and large, if it's a felony level offense, these cases proceed to a jury trial if we can't come to an agreement. Some of the offenses that we charge are theft. We also charge insurance fraud, money laundering, engaging in organized criminal activity. There are also a number of criminal statutes that appear in Chapter 418 of the Labor Code that we can charge. But by and large, we're only charging felony offenses. We don't really have jurisdiction or authority over most misdemeanor cases here. A little bit of a unique process that occurs in workers' compensation in our criminal cases here. Our arrests generally occur after there's an indictment. So what's normal in a criminal case is for like a police officer to make an on-site arrest, or an on-view arrest is what they call it, because he or she observed criminal activity in progress. That person gets taken to jail, there's the arrest, they later bond out, and then the case proceeds to the indictment process. And if it's indicted, that person has to come back to court. That's how typical criminal cases proceed. Our cases are a little bit different because we don't have on-view arrests. We don't have a police officer standing around while that person is committing fraud. So the way that our cases proceed is we have an investigation, followed by a grand jury hearing, followed by either a summons or a warrant that comes out from the clerk's office, followed by an arrest. So a little bit of a different process in our case. And again, that's because we don't have police officers on scene actually observing offenses as they occur in real time. Individuals and corporate defendants are treated a little bit differently in the system. With an individual, there's going to be a warrant that gets issued for that person's arrest 9 times out of 10 after there's a grand jury hearing, and that grand jury true bills the case. With corporate defendants, it's a different process because there isn't an actual defendant to arrest. Instead of an arrest warrant being issued, what we have is a summons that gets issued to the corporation, and then the corporation appears by essentially their attorney in court. It's not a situation where we haul the CEO into court. They appear via counsel. Quick note on corporate defendants. Basically, just because you work at a corporation or a business and you commit a crime doesn't mean that the corporation is now a defendant. It's got to be more involved than that. So you need to have an agent that's acting on behalf of the corporation within the scope of their employment in order to get your hands on a sort of corporate defendant. Additionally, there's a way that maybe a majority of the governing board authorized or tolerated a criminal act that would put the corporation itself on the hook for criminal liability. And then also, if the actor, that's going to be the person who's committed the crime, is a high managerial agent acting on behalf of the corporation. That's going to be different than just if some low-level employee committed an offense. in which the corporation would not be a defendant in that case. But it changes if the person who commits the crime is actually a high managerial agent. Another unique thing about corporations is they can be tried in what's called absentia. For a criminal trial to take place, most of the time, unless somebody has voluntarily absented themselves, which is a fun way of saying they fled, you have to have a criminal defendant sitting in the chair in order to proceed with the trial. That's not true with a corporate defendant. Again, there's no defendant to arrest, so there's not necessarily anybody to put in that chair. So a trial can proceed even if the corporation doesn't show up, which is a little bit different, and it's certainly evidence that Texas kind of disfavors corporate defendants. Or at least one point when these laws were being written, the legislature disfavored corporate defendants. Penalties range anywhere in our cases from state jail felonies to first-degree felonies. So that's either state jail time, which is it's a prison that's kind of in between county jail and the Texas Department of Criminal Justice Institutional Division, big prison. There are these more local facilities that house a smaller number of inmates that are there for felony offenses, but sort of lower level felony offenses. Your small level drug cases, some of your other less egregious felony type of offenses. There's a dozen out there. But they range all the way to first degree felony offenses, and that can be anywhere from 5 to 99 years in prison or life, and up to a $10,000 fine. Corporations, again, are a little bit different. We don't have any provision for probation for a corporate defendant. That's for a number of reasons. One, there's not an individual to put on probation. And two, there's no threat of them being sent to prison if they violate probation. So there's no probation for a corporate defendant, but the fines are significantly higher for corporate defendants. Felony offenses carry with them up to a $20,000 fine in most cases. You can also seek up to a $50,000 fine if it's a Class A misdemeanor or higher, and whatever fraudulent activity that the corporation engaged in involved either serious bodily injury to a victim or death. Not commonly encountered in our workers' compensation fraud cases, but it is there. And there's another option here. If a court determines that somebody is guilty, that a corporation is guilty, or a jury makes that determination, a court can double the amount that was lost by the victim of the fraudulent scheme, or double the amount that was actually gained by the corporation. This is a provision that doesn't appear anywhere else in criminal law. And again, this is designed to address this sort of systemic corporate behavior that would involve fraud. There are a number of different outcomes that we have in the criminal justice system. Specifically here in Travis County, we have what's called a pretrial diversion program. What pretrial diversion is it's essentially like a probation that occurs outside of the court system. What happens is the state and the defendant enter into a contract under which the defendant agrees to either do a number of things or refrain from doing a number of things. And there are some other conditions attached to. In these types of cases, typically it's going to be the repayment of restitution. That would be one of the terms and conditions of that pretrial diversion. And at the end of it, if the defendant satisfies all of those conditions, the case ultimately gets dismissed. Hopefully the victim has been made whole, and the defendant has decided that they're going to change their ways. That's the ideal outcome. In any case, we can order restitution, whether it's a pretrial diversion, whether it's deferred adjudication, whether it's even jail time or prison, we can order restitution. And from pretrial diversion, just the penalties increase from there. So we do have what's called deferred adjudication that I mentioned a second ago. That's a similar process, but that's a probation that occurs inside of the court system. So you'll actually have a probation officer on that case. And again, these are all outcomes for individuals, not corporations, because as I mentioned, there is no probation for corporate defendants. And then we have straight probation. The difference between deferred adjudication probation and straight probation is that with deferred, the defendant isn't ever convicted if they do their part. They can certainly be convicted if they're revoked or adjudicated later on, but if they do their part and they don't get in any new trouble, that case ultimately gets dismissed and they get the chance to avoid a conviction. A straight probation, or what we call straight probation, is a little bit different. That involves a conviction, and instead of going to prison for that felony offense, they get placed on what's called community supervision or probation. Again, in that instance, if they violate the terms and conditions of their probation, which is generally in these cases going to include the repayment of restitution and, in the future not committing any new offenses, or at least during the probationary period, not committing any new offenses. If they satisfy all of those conditions, they get discharged from probation, and everybody kind of goes along their way. The maximum number of years that you can be placed on probation in Texas is 10 years. And so with these bigger cases that involve hundreds of thousands, if not millions of dollars in restitution, you might see a defendant placed on probation for that amount of time. Kind of a controversial point that is worth bringing up. A lot of people, when they feel like they've been harmed by an individual, let's keep it in the context of an individual, they want that individual, that criminal, to go to prison. The problem with that is, I get that. Like, if they've committed a crime and it's one of dishonesty, there's a good chance they might belong in prison. If you want restitution to be paid back to you, if that person's sitting in prison, there's nothing that they can do in order to pay that restitution. So just understand that there are some trade-offs when a defendant does go to prison. There's basically no avenue for you to pursue restitution in that case, at least not through the criminal justice system, because that person's not out working, they're not making money, they're just sitting in prison. That being said, there are cases that absolutely the defendant deserves to go to prison for what they've done, but also understand that there are competing interests here, and the other interest is making sure that the victim gets made whole. And again, we can't do that if somebody's sitting in prison. And then at the other end of the spectrum here, we have county jail, which can be a condition of probation from time to time, or it can be the ultimate sentence, and we also have prison. As for restitution, it's not going to be limited by the offense level. So let's say we have a state jail felony, but we have $1 million that we ultimately discover is due in restitution. $1 million is outside of the level of a state jail felony, but the court can still order $1 million of restitution even though the charged offense is just a state jail felony. So understand that our prosecutors are making tactical decisions about what specific offense to charge, and a lot of that's going to be based on the evidence that they have, how their juries behave, how their jurisdiction is. But also understand that if they do charge a lower level offense, we're not going to be limited in our restitution number. So we can still pursue the highest number that the facts and circumstances support. The thing about restitution is there has to be a factual basis in the record for that restitution. And we have to prove that the defendant's crime was the proximate cause of your loss if you're the victim in a case. Here's what criminal law doesn't allow for. Basically, a contract recovery is not going to be something that you can pursue in criminal law. That's something that you would have to pursue in state court. So let's say I'm a criminal defendant and I've got a contract with you in which I agree to pay you $1 million, right? During that contract, I steal from you $100,000, and I've breached the contract by committing a violation. Essentially, I've committed theft. I've stolen from you, but I only take $100,000 from you. In the eyes of the criminal justice system, that's what you're out, is $100,000. It's not the full value of the contract. It's just the $100,000, because that's all that the state is going to be able to prove is the proximate cause of your loss. So just understand that it's a little bit different, but just because somebody is being prosecuted in the criminal justice system doesn't mean that you can't go and pursue a cause of action in the civil justice system. So that kind of wraps up everything about compliance and investigations. I hope this has been a little bit more illuminative. Understand that there's still probably a lot of uncertainty as to how we do things and why we do things here. And like I said, 99 out of 100 of y'all are doing everything right in the overwhelming majority of instances. But for whatever reason, if you do find yourself navigating these waters, I hope this presentation helps you a little bit and kind of puts your mind at ease as to some of our processes. And I look forward to hearing from you with any questions. Thank you. All right, thanks for attending today's CompCourses, everybody. I hope you learned a little bit more about compliance and investigations. I hope it shed some light on what we do over here, and I hope the process isn't as much of a mystery as it probably is. Just as a reminder, if you do want to receive credit for the course today, You need to stay through the entirety of the Q&A process. And I'll be here. If you have any questions, you can just drop them down in the Q&A tab. I'll probably answer them verbally over screen as opposed to continuing typing. This function doesn't have like a spell check, so I'm going out of my mind a little bit, trying to make sure that I'm spelling everything as I'm typing so quickly. But I'll stick around. If you'll have any questions, feel free to drop them in the chat. Okay, so Joy Cortinas, you have a question. Is it just complaints against a workers' compensation insurance company that can be filed, or can you also file a complaint against a company? You can file a complaint against any system participant. It doesn't just have to be a carrier. It can be anybody that we have jurisdiction over. And then we have another question. Does TDI have oversight for workers' comp complaints against federal programs if worker or services are located in Texas? Um, so if it's a federal case, we would probably identify that pretty soon, pretty early on, and we'd refer it out to the proper federal authorities. Federal offenses are prosecuted in federal court, and we don't have anybody embedded in federal court. We're just operating in the state system. I hope that answers that question. Okay, so we have another one. What if it's a complaint against a doctor at a clinic that makes a decision that's beneficial to your company, but you know it's not right or potentially not legal? Uh, that's getting into an area of legal advice. I would say um, defer to your own conscience and defer to your own legal best interests is probably the best advice I can give you on that without stepping into the shoes of actually being your attorney on that. So sorry, I kind of dodged that one. It's a very lawyerly thing to do. It's kind of my ethical obligation at this point. All right, we have another one from Stacy. Does being a private or public employer make any difference on how the cases are processed? No, the nature of the entity that we're looking at doesn't really change the way that we're taking cases in. We're just seeing if it's a violation or if a criminal action has been committed. Okay, we got a question from Emily. It's kind of a hypothetical, so I'm going to do my best with it. So, say an employee is on workers' comp and receiving workers' comp, but he or she is doing roofing or volunteer firefighting while on workers' comp, and you have proof of that, other than stopping the workers' comp payments. The company is out of the money unless the company sues said employee. Correct? No. So what I'm gathering there is a working and drawing situation where you're saying that I'm too injured to work or I'm too injured to make my previous salary, my previous wages, and so I need workers' compensation benefits. And then you're going out and getting extra employment. So you're kind of double dipping there a little bit. That's something that we can pursue. And in that instance, part of the case resolution we would try to get for you would be restitution on the case. Nothing would prevent you from filing a separate civil lawsuit, but I would leave that in more qualified hands than my own. I can't advise you on a course of action in that regard. Okay, so Roger, you have a question with the new ruling regarding independent contractors. If a contractor is hired by an employer and the employer now assumes the job description and wages, can the independent contractor file for workers' compensation? I'm going to have to defer to a different authority on that question. I wouldn't be able to give you advice on whether that person can file or not. So I apologize. It's just sort of out of my wheelhouse. Yeah. Stacy, what does PRI stand for again when it comes to the case for a complaint? It's the problem report incident. Like everything in workers' compensation, there's an acronym, which was super frustrating and annoying when I first showed up, but now I've kind of gotten used to it a little bit. Yeah, it's just problem report incident. It's just how we refer to the number or the complaint internally. Just to keep track of it. It's easier for us on this side. Is there a statute of limitations to file a complaint? I'm assuming this is an administrative violation complaint. No, there is not. However, the best practice there is to file that complaint as soon as you know about the violation that has occurred. So one caveat there is the medical fee dispute rule that I talked about previously that was amended. If you do have a complaint that relates to a medical fee dispute, it has to be brought within a calendar year, 365 days of the date of service, giving rise to the complaint. So generally speaking, no statutes of limitations on complaints, although you are restricted in being able to file a complaint on a medical fee dispute issue to just that 1 year. Okay. We have a question from Anonymous. I have a claimant who files a complaint on something about every other month. We've had 12 in the last 2 years. Does the DWC ever look at this as harassment of the carrier by the claimant? Only one of those complaints resulted in a violation for late payment that was late by just 1 or 2 days. No, harassment's not something that we're specifically looking for. There is a criminal harassment statute. There's online harassment, and there's just regular old traditional harassment. Those aren't laws that we enforce. That would be, local law enforcement, whether you're here in Austin or outside Austin. But yeah, that's just not the type of criminal offense that we're even allowed to touch. Sure. Joy, can an administrative offense turn into a criminal or vice versa? Absolutely. Yeah. There's nothing that would prohibit us from if we're investigating a case, let's say, there's nothing that would force us to turn a blind eye to other evidence that we gather. Luckily, the enforcement people and the administrative side and the criminal people, all the fraud investigators, they're all under the same umbrella here in compliance and investigations. My directors meet once a week and we relay information to make sure that we're sharing everything up to date, keeping everybody in the loop in case that there is a joint investigation. Actually, our rules do contemplate the possibility of what's called a parallel prosecution, where you have an administrative violation that accompanies a criminal violation. They're super rare, and I actually gave an ethics presentation on this somewhat recently. There are certainly some pitfalls in navigating those as far as being on the other side of them or representing somebody who's being prosecuted in both of these capacities. But yeah, it happens, and it's certainly possible. It's just somewhat rare. Usually, administrative violations are contained to just more civil type of infractions, and then the criminal stuff is more traditionally criminal, your fraud and things like that. But yeah, great question. Who do I contact to check the status of a complaint? Yeah, you can call us. So I've actually got a phone number, and there's also an email address. Let me pull it up for you real quick. Yeah, so telephone number is 512-804-4700. I'll probably type this in the chat. Or you can email us at dwccompliancereview@tdi.texas.gov. I'll drop this stuff in the chat. Give me a second. That way you have it memorialized. But yeah, by and large, the complaint stuff is confidential, so we can't just give out information to anybody. All these workers' compensation complaints are protected under the labor code. Um, but you can always call and check on the status to see if it's been resolved or if it's still pending. So yeah, I'm dropping that into the chat right now. Hope that helps. Okay, so Stacy, are TDI cases handled via mail, email, or portal? Um, I don't know specifically if you're talking about like what I call big insurance TDI. The other side, I don't really know how they do business over there. I'm sorry. We're a little bit siloed over here, specifically just doing workers' comp, whereas TDI does the larger insurance stuff. I hope that helps. Or if you could refine the question, I could probably get you to an answer. Okay, so Kayla, how many times can they appeal? Well, in the criminal justice system, appeals go from district court into the Court of Appeals. The way that Texas is set up, we have two high courts. So over here on the civil side, you have the Texas Supreme Court, Supreme Court of Texas, and then for criminal cases, you have the Court of Criminal Appeals, or what we call the CCA. Criminal cases ultimately go up to the Court of Criminal Appeals. They don't go to the Supreme Court of Texas. But you're not losing out on anything because the Supreme Court of Texas doesn't handle criminal cases. So you are going to the Supreme Court of criminal cases. So basically, it's two appeals in the state system, barring some sort of weird action where you take it to an appellate court and then it gets kicked back down to a trial court for a particular finding, then it goes back up to the appellate court. Um, that's uncommon, but it's possible. It's the law, so like everything is possible. But generally speaking, there are two paths to appeal. There's the appellate court, and then there's the Court of Criminal Appeals. Um, and then from there, you have the possibility of having some sort of federal review. But we don't handle anything in the federal system over here, and it's kind of again outside of my wheelhouse. We're just doing state stuff for the most part. Okay, so anonymous, how does DWC determine the type and amount of sanction assessed? So some of it is just statutory. We have complaint priorities. We have, in our rules, we have aggravating and mitigating factors that we consider. A big part of it is how egregious is it? If did somebody get hurt by this? Did somebody, was somebody entitled to benefits and they didn't get them? And, that was the money that they needed to keep the lights on, so to speak, or pay their mortgage or whatever it is. If they were entitled to it and they didn't get it, and their personal lives suffered as a result of that, that's kind of a big deal for us. Those are the things that we're going to judge a little more harshly. Uh, Short answer is it's the facts and circumstances of the case. Everything is given individualized consideration, but generally speaking, as well, we try to be consistent across the board with our penalties. We try to match them to, fact patterns that we know of already in cases that we've resolved. Okay, Michelle, scenario. Company does not have workers' comp policy, and while workers on the job, equipment being used fails and tragically results in several people injured, including one loss of life. Will the worker be charged as a criminal offense or is company held liable? Yeah, I'm gonna have to refrain from answering that too. It's a very specific fact pattern. If I was still a courtroom attorney, I'd call that a commitment question because whatever I answer to that might be something that you're looking to get as a commitment from us moving forward. I'd have to know more. I'd have to just know more of the facts and circumstances before I could personally form a conclusion. And even at that, I couldn't really, in good faith, opine on it, just given that it's more legal advice than just general policy or practices over here at the division. Again, sorry. Um, I know that feels like I just punted because I did, and I apologize for it. But again, it's like an ethical requirement for me. I can't give legal advice to somebody that I don't represent. Okay, Monica, while checking the status for the complaints, what information are you needing? DWC claim number or the IC claim number? So you should have a copy of the PRI number. over here. If you just hang on to that, that's a very quick reference for us to be able to go and actually pull it and give you an update. So yeah, that PRI number is essentially it's a cause number for us. It's just how we reference cases. Do whistleblower laws apply to a person filing a complaint? I don't know, but complaints are anonymous over here. So nobody, if you do file a complaint, nobody outside of um, really A&I and audits and investigations and enforcement is going to know about it. So I wouldn't tell you to worry. I mean, again, that's going to be a matter for you to best judge what to do and how to act. But our complaints are anonymous. Okay, anonymous. How do you best document or should document if the workers' compensation case asks you verbally overlooked or delay their return to work for continuing their benefits? Okay, let me unpack that for a second. Okay, so the question is really about documentation. Um, I would defer to whatever your company policy is. I can tell you this, written documentation in the court process is very effective for us. We can admit those types of documents, given that we have an accompanying business record affidavit or something like that. So I can tell you this, written documentation is always best for us. If it's said verbally, it basically didn't happen. Um, that's a bit harsh, and that's not always true in the legal system, but by and large, written documentation is going to be best. Okay, David, is it a good idea for a company to refer an employee to the DWC Ombudsman program if they have questions about the claim process? I would say absolutely. Another thing that we have over here, another resource, is our customer service folks. They're very knowledgeable, and they could probably steer that person in the right direction. Yeah. Okay, we're right at the 2 o'clock hour, a little bit after actually. So we'll go ahead and wrap things up here. And yeah, and that's where we'll end it. I want to thank you for joining us today. If I didn't get to your question, feel free to stick around or reach out to me. I'll type um, my email address here in the information. That way, if you didn't get to have your question answered or you didn't think of a question until right now, you can shoot me an email. I'll do my best to answer it. And we'll have a survey at the end of the webinar. So if you please could fill that out, it kind of helps us moving forward, figuring out, what we did right, what we did wrong, what y'all would like to hear in the future. And really that information does inform how we proceed. So thanks again for being here. Hope you learned something, and I'll see you on the next one.